the ordinance that offers entail.
Thank you. Good morning, Your Honor. May it please the Court. I'm going to address a couple of issues. One is that what is the scope of the county's legislative authority, and we feel that substantial parts of both of these enactments exceed that scope. And I'm also going to talk about some of the constitutional questions. First of all, Columbia County, of course, is a statutory home rule county. It does not have a charter. And so the scope of its legislative authority is set forth in ORS 203.035, and basically it gives a pretty broad plenary authority to legislate as to matters of county concern. Now, the law about what is a matter of county concern I find to be both complex and confusing, and I think largely the reason for that is that most of the case law arises in a very different circumstance. It arises in the circumstance where a charter county is affected in some way by a state law, which impinges on the county's operation in some way. And then there's a whole constitutional restraint in terms of the state's power to do that. That is a very different situation than what we have here. And actually, the key case in this area, I think, is GTE Northwest versus the Oregon AUC. And it tells us that we're not supposed to look at that law because it involves other kinds of considerations, namely the constitutional restrictions on the legislature to impose upon the form of government of the charter county. And those issues are at stake here. When you take out those cases, there's very little case law actually talking about what is a matter of county concern or not. But GTE, again, does give us some guidance. And basically, what it says is there something that is predominantly a statewide issue or predominantly a county issue? The issue involved here, employment of persons who are undocumented, is a matter of state concern that the state has expressed a policy about. And that policy is reflected in ORS 181.850. 181.850 basically says that law enforcement agencies are to spend public funds investigating or detaining folks who are unlawfully in the United States if that's their only crime. That's basically to be left to the federal government. And state, if you go back into the legislative history of that statute, what you find is the concern was that for better expenses of local law enforcement dollars than going around chasing people who may be in the country illegally. We have the federal ICE agency that's set up to do that. Counties aren't particularly trained to do that. It's not a good use of county resources. Now, I have to concede it's not a direct conflict with that statute, because even though the county attorney or the district attorney or whoever enforces this would, in some sense, be a law enforcement person, if we parse the language of 181.050, it doesn't fit the definition of what a law enforcement agency is. Nonetheless, the state legislature has expressed a broad state interest, a broad state policy in leaving alone the enforcement of immigration law, and this measure attempts to do that on a local level. Our argument would be that the statewide interest predominates, and therefore it's not a matter of county concern and beyond the legislative authority of the county. Beyond that, there's another issue, and that is both the measure and the ordinance are not limited to the employment of unauthorized persons within Columbia County. They also affect employers who may have a building permit, for example, in Columbia County, but the employment involved may have taken place in Oregon or somewhere else. Is there something I can help?
Yeah, could you refer me to that portion of the ordinance that you're discussing now?
It's the measure, section 1, sub 4 of the ordinance is section capital I, capital G. Again, the way this works, it has to do with the definition of employer. And the definition of employer is so broad that it clearly applies to people employing anyone anywhere in the state who has a permit or has a license in Columbia County, including state work.
Which page of the ordinance is that on?
The first page after the tax page, Your Honor.
That would be page 4 of the county's exhibit 1.
So is it your concern that you would have the prohibited activity taking place potentially in a different county, but then an action brought in Columbia County to that would affect that employer's ability to obtain or maintain building permits?
That's correct.
Okay.
That's precisely the concern. And our argument is that even if it's true that the county has legislative authority, we don't think it does, to regulate employment of aliens inside the county, that taking its investigation to what happened in Boardman is beyond the legislative authority of the county. We believe that the measure itself impermissibly strips the legislative power of the county commission. The City of Roseburg case would say that the grant of legislative authority to the people of the county is not is basically a grant of sharing authority, but it doesn't in any way diminish the authority that the commission would have to pass legislation. And by locking the measure in law and requiring it to be resubmitted to the people, that sort of undercuts that. Not sort of, it wholly undercuts the ability of the county commission to legislate, which is a co-equal plenary power that is shared with the people. It's not that the people can't also legislate. If they're unhappy with amendments that the county makes, then the proper response would be to pass an initiative to pass a different law. But you can't, in that law, deprive the commission of the authority to legislate. So that also is beyond the legislative power.
So what you're saying is that